Good morning, everyone. We'll just kick off with a karakia. Hokirumo ki a rangi e tūnei, hoki raro ki a papa e whakautou nei, hoki roto ki te nākau tangata, hoki waho ki tēnei hui, haumie huie tāie.
Tēnā koutou katoa, nō mai haere mai ki tēnei hui, ko Robert Scott tōka ringo. Hello everyone and welcome to day 4 of hearing 4 of the proposed Far North District Plan hearings. My name is Robert Scott, I'm the chairperson for the proposed district plan hearings. With me for this hearing is Commissioner Doug Watson, and on my right, Councillor Felicity Foy, Commissioner Siani Walker, and Commissioner Peter Kensington. Our first submitter this morning, I believe, is the Haitito Naranga Morai Trust, and you're going to be delivering your submissions online. Can you see us and hear us? And if so, can you turn your cameras and microphones on? Kia ora, welcome.
Good.
Okay. So we'll hand over to you to present your submissions.
Oe te tuatahi e mihi ana ki te kai ala whata ki te ronga te la nei kua whakatau nei te ahua te pai. I runga i a tātou I mua mai te tīmata mai o tēnei tō tātou I te la nei. Mai e huri noa e te kauni hera I a tātou a tēnā koutou katoa. Can I just check that you can...
Yes, we can hear you and we can see you. Thank you.
Cool, thank you. Sorry, I've just got a bit of feedback, so I wasn't quite sure. I assume everybody's had the opportunity to read the statement of evidence that was provided.
The submission or?
Yes, the submission that was made by me.
Yes, we read your submission.
Okay. Do you have any specific questions in relation to the information contained within?
There's no, I don't think there's a statement.
Just to clarify, we haven't received a statement of evidence aside from the submission you've obviously provided.
This is a submission dated the 7th of August.
Oh yes, we have that submission. So what we do is normally you put in a submission when the district plan is notified, and then you have the opportunity to prepare a written statement in support of your submission where you can respond to the council's report and what have you. Is that what you want to do today, or do you want to speak to your submission?
The statement of evidence that was written on the 7th of August 2024, I think is what TPN is referring to.
Okay.
I don't think I've received. I haven't received that.
Okay, look, I think we can sort that out. Do you have that statement in front of you?
Yes.
Okay. Well, then what I think we should do is we'll have you read your statement in full, and if you could then email that to Alicia Kate, we can have a copy of it. But unfortunately, I apologise for the mix-up. We haven't had the ability to pre-read it. But having said that, you're not expert witnesses, so we would have got you to read your statement of evidence to us anyway. So why don't we do that? So whoever wants from you can read the statement together, or one of you read it. We don't mind, but we'll hand it over to you. We'll give you sufficient time to read out your evidence.
Oh, kia ora.
Kia ora. Karen, are you happy for me to proceed and read these? Okay. Ko puwheke te maunga ko māmaru waipapa me rua kara mea ngā waka, ko tokerau me karikari ngā moana, ko Ngāti Kahu te iwi, ko te whānau moana me te rorohuri ngā hapu o ronga, ko Haitito Maranga te mara. Te whānau moana and te rorohuri are the two hapu associated with Haitito Maranga. Our marae was named after the mokopuna of our founding Ngāti Kahu tūpuna, Kahu Tianui and Te Parata. Te whānau moana and te rorohuri are two of the three hapu that arrived on the waka Māmaru. The other hapu on the waka was Te Patu Koraha, whose descendants reside in Karaponia, Awanui. Our moana or coastal environment is a taonga to us and forms a significant part of our identity. This is highlighted in that the name of one of our hapu te whānau moana literally translates to the sea whānau or sea family. Our pepeha features kari and tukarau moana rather than awa, and the full name of our maunga is Te Puke o Te Wheke o Muturangi, which translates to the octopus hill of Muturangi. It was named after an event that occurred in our moana. Te whānau moana Te Rorohuri, a mana whenua of the Karikari Peninsula, and indeed the mana moana of the surrounding waters. I'm a descendant of whānau moana Te Rorohuri through the following whakapapa lines by Te Parata, Te Māmangi, to Kanikani Hāpute, Heiti Taumarangai, Hunga Hunga, Hutu, Tuki Whakauka, Mauhara, Te Nganga, Ngā Pauri, Ruarei, Meriana Ngā Kohi Kohi, Poharama, Reihana, Ngāreta, Manu, and myself. I was born and raised in Christchurch in the South Island until the age of 15 years. Growing up, we took regular trips home to visit our grandparents who were living on the farm in Wairahoraho Valley on the Karikari Peninsula. My elders were my teachers. Our father impressed upon us the importance of contributing to our whānau hapu, marae, church, mana whenua, and mana moana. I was fortunate to have the opportunity to learn from my kaumātua and kuia, and I am grateful for the lessons I received. I now sit on the taumata at our marae. I've been involved with different governance entities associated with our rohe. I held a role as the chair of the Haititai Marangai 339 Trust until recently, and am still a trustee currently on that trust. I also held a role previously as the chair of the Ngāti Kahu Stationahu Whenua Trust, and I am the current chair of the Haititai Marangai Kaitiaki Trust. I consider the matters addressed in Kariana Hita's evidence. I agree with and support the point she makes in relation to our position and role in our rohe, our tikanga, and our connection and responsibility to the environment. I also agree with her views expressed in relation to the Ngāti Kahu Rūnanga. Our relationship with Te Taiao is one that is intrinsically tied to tikanga and identity. According to our tikanga, all things are interconnected. In our view, it is artificial to treat things like river margins as separate from the rest of the Taiao. As Kaitiaki, we must fulfill our responsibilities and obligations to enhance and sustain Papa Tuanuku and her children. The Kaitiaki principle of guardianship catches some of the obligations that we as tangata whenua have, noting that other obligations on tangata whenua are covered by other markers. Our culture and traditions, or tikanga markers that guide our engagement with our rohe, include whakapapa and genealogical connections, whanaungatanga, kinship, mana, authority and responsibility, kaitiakitanga, guardianship, tapu, restrictions, noa, free from restrictions, utu, reciprocity, and air, balance. The principles of rangatiratanga, kaitiakitanga, whanaungatanga, and mana botuhake are integral to the proper operations of our traditions. These things are further enhanced by our relationship with the whenua, moana, and its many life forms, and our understanding of when, where, and how to care for and utilize said whenua, moana, and awa. Our rohe has provided a constant source of spiritual and physical sustenance for our hapu, with its resources managed effectively to ensure sustainability. Hapu knowledge and practices in relation to our rohe have been passed down to each successive generation. There is a renewed focus on the well-being of our rohe by our younger hapu members. It is important to recognise the interconnectedness of kaupapa and tikanga. When contemplating issues in relation to the moana, our kaumātua would decide what rules and principles, kaupapa, would guide their decision-making. They would recount past events to assist in their discussions, and then a course of action or tikanga would be agreed to. The relevant tikanga markers traditionally guided this decision-making. It is also important to understand that our culture, traditions, and relationships are dynamic and context-specific. For example, Council recently recognised areas that contain koiwi, human bones as wahi tapu. This has helped to provide a form of proper protection of our culture. On the other hand, Council's wastewater system has leaked into Tokiro Moana. You can smell it on the beach. The offence caused by failed systems desecrating one of the moana that feature in our pepeha cannot be underestimated. Now let's talk about taonga species. In reference to the kuaka, te kuaka, he kuaka marangaranga tahi manu I taiki te tahu na tauatu taumai. Kuaka used to frequent our rohe. They're not seen very often these days. The banks of Waimango, the swamp, provide kāinga for pārera, ducks, karaka here, the grey duck, wana, swans, kuaka, the godwit, the mātuku, the Australasian bittern, the tūturi whatu, the banded dotterel, the pūeto, the spotless crake, the taranui, the Caspian tem, the mātātā, the fernbird, and the tara, the white-fronted tern. Waimango was a spawning ground for the pioke shark, a place to catch panai or mullet. All of these creatures contribute to the balance of Te Taio. Their presence tells us when it is well. Their absence tells it when it is sick. I understand that some of these species are heading towards extinction and that numbers are declining due to the decline of the health of our rohe, particularly in Waimango. In earlier times, Waimango was a part of the Karikari Peninsula. Over time, the beach and sandhills built a natural wall that formed a lagoon or wetland. Waimango was a part of a catchment that begins in the hill range we know as Pai Tehe Tehe Roa. Waimango receives impure water, including surface water from activities upstream and in the surrounding lands. Today, Waimango is not healthy or well. It no longer supports taonga species like the mango fish and birds it once did. Waimango fluctuates in area and depth, and depending on how freely water can flow out to the sea and how much water it receives from its tributaries or from rainfall. Waimango has been modified previously by the Lands and Surveys Department. Its size and depth has decreased and the sand dunes have been reduced also. This was done to support the Crown-owned block at Rangiputa. I tautoko the evidence that our kaumātua Atihana gave on Waimango in another hearing, and I understand a copy of that should be attached to the original documents that you should or are going to receive shortly. During my time as a trustee and chair, we have dealt with countless applications for consents. At times we've had to intervene because applicants and council forget that we are here. My experience is that council treats our interests as superficial. Resource consent applicant goals and aspirations for development seem to take precedence over our obligation to protect our rohe. A number of times we received applications via council and were given 5 days to respond. That is a big ask of people who are functioning on volunteering time. It is important that council do not ask applicants to do their homework on cultural impacts before they file applications for resource consent. We have witnessed our rohe becoming increasingly unwell. The reduction in bird numbers indicates the lack of kai and the ever-increasing harm, and this is disappointing. Consent holders come and go, and we are left to clean up, to try and restore the harm that occurs within our rohe. I would have thought that our values, traditions, and the relationships that we have with our rohe should be a clear front-end consideration. That's my statement. Can I just add in summary that I'm mindful that every council is looking at the issue of economic development, but the very things that attract people to our place is the fact that we had clean and clear waters around our coastline. So the very things that are attracting, or that did attract people to our space, are not necessarily going to attract them again in the future with the amount of sewage that potentially goes into the moana and through Waimango and polluting our areas both on the sea and on the land. That, combined with the arrival of the Callirpa weed, creates a real problem because the thing that attracts people to our area is the moana. And the way things are going, you're not going to be able to eat or take anything from the moana with the level of pollution that's going in there. So that's my submission for this morning. Kia ora.
Kia ora. Thank you very much for that. And again, sorry we didn't get that copy of that evidence. If you want to put that through to our hearing administrator, we will all have a look at it again. But I think we just want to acknowledge your association with the land and your role as kaitiaki. And thank you again for your stewardship and concerns raised regarding the health of the waters that surround you. I was going to see if the panel has some questions for you.
Morena korua. Nā mahi nui I te kōrero ki a koe tipene. Morena Karena. Thank you for that presentation this morning, and the kōrero, as the Chair has said, we'll get your statement to us later sometime today. And as you say, many people flock to the peninsula, as you say, for the moana, the pristine, the beauty, all of those things. And as you say, if those values and traditions and, that make that a unique place aren't looked after, then that's not good for the hukainga or the home people, let alone those visitors that want to come and stay and have their batches there, as that place is becoming a business. I had a couple of questions, in particular with the Council's Section 42A. There were a few things that the planner was looking for some response, sort of content or comment. So that was something I sort of wanted to ask a couple of questions around. But yes, kia ora, Karina.
Oh, kia ora. I just thought before we get into the questions, I do have a statement that might respond to some of those questions you have.
Yes, sir. Kia ora.
Okay, thank you. Oh, and I'll just go ahead and this would have been the other statement that would have been received with TPN's statement to help with today's procedure. Sorry, I'm not too sure what happened there. But in any case, I'll if it's okay, I'll start to present mine. These submissions are filed on behalf of Haititai Marangai Marae Kaitiaki Trust. I've been asked to speak to the trust submission. While I'm not a trustee of this trust, I attempt to represent the concerns and desired outcomes of the trust and the hapu that it represents on this matter, and to reinforce the matters made in the submission that was endorsed by this trust and the Haititai Marangai Marae 339 Trust. We would have liked to have supported your decision-making with technical evidence on a number of those submission points, but our ability to commit the considerable funding required for each hearing week is limited. As a result, the Trust has chosen to reserve funding for later hearing weeks and to support your decision-making with expert cultural input from Mr. Paul Tipene. We urge you to consider the technical evidence presented by other submitters, particularly those submitters that are seeking provisions that ensure maintenance and enhancement on the environment, such as the Department of Conservation. Like many other hapu, our people have been alienated from much of our land through unjust land acquisition and resource exploitation by the Crown, its agents and manuhere within Aotearoa. Not only have our people lost the land they relied on for their well-being, the development of that land by the Crown and others and the lack of sustainable management has led to the degradation of Aotearoa. We suffer significant multi-generational impacts on the social, cultural and economic well-being of our people. Unfortunately, our hapu is yet to complete the treaty settlement process. While this will not replace what has been lost, we hope to see at least some of our lands and taonga returned. What will be difficult to resolve is the environmental degradation that has occurred and is still occurring on the watch of others. While we wait, we do not want further undermining of our rangatiratanga or further erosion of our culture, traditions and relationships with our whenua, awa, roto and other taonga. Council has a critical role in making sure that the values, traditions and inter-entity relationships of our hapu are addressed properly within our rohe. The proposed is an important mechanism to achieving this. Hapu values and relationships. The Trust understands that the proposed plan is meant to implement national level planning instruments like the Resource Management Act. The Trust also understands that Section 6 of the Resource Management Act requires decision makers to recognise and provide for Māori culture, traditions and relationships that they have with ancestral lands, waters, sites, wahitapu and other taonga. Recognise and provide for are verbs. The words highlight that an action or an outcome is required, being something more than consideration. Mr. Paul's evidence sets out that at the moment, council and resource consent applicants seem to struggle with understanding that something more than afterthought or light evaluation is required. To this end, it is important that the proposed plan provides clear guidance to future plan users. Cultural effects assessments. As Mr. Paul identifies, our hapu have experienced challenges in having a meaningful say and visibility in decisions concerning our rohe. Regarding the coastal environment, the Trust requested a new policy to identify what types of effects are acceptable. That's the 394.045, avoid significant adverse effects and remedy or mitigate other effects, adverse effects on cultural values. The Section 42A author suggests that this is already provided for by TWP 6, which sets out matters to consider in evaluating applications. Considering applications is different from specifying what level of effect might be acceptable in cultural terms. The latter sets an upper limit to harm that may occur in terms of our interests. That is not the same as thinking about or considering the level of harm and then setting that evaluation to one side. Regarding outstanding natural features and landscapes, the Trust requested a new policy to identify what level of effects is acceptable. That's S394.039. Avoid any significant adverse cultural effects and avoid, remedy or mitigate any other adverse cultural effects. The Section 42A author does not support inclusion of the above policy, as the author is not clear on how it relates to outstanding natural features and landscapes, noting that cultural associations are already a criterion. Similarly to the above, cultural matters forming a part of the evaluation at the beginning does not translate to outputs or recognition and provision for related cultural traditions and ancestral relationships. For example, Waimango was identified as outstanding. Mr. Paul and Mr. Johns identified the significance on Waimango. And any harm to Waimango has a corresponding impact on our hapu, given their entwined connection with Waimango. On the round, it is difficult to see how the interests of our hapu could be recognised and provided for where a plan allows significant harm to occur. Natural character. The Trust requested a new policy in the natural character chapter, S394.042. It says manage the effects of activities adjacent to surface water by avoiding significant adverse cultural effects and remedying or mitigating other adverse cultural effects. The Section 42A author does not support the inclusion as the focus is on the natural character values of freshwater margins. The author does not have a clear understanding of how the proposed policy relates to natural character values. Te Tangi a te Manu provides guidance for landscape assessments. It identifies that landscape is unavoidably cultural and that landscape is composed not only of what lies before our eyes, but what lies within our heads. Each of the dimensions is understood through cultural concepts and values. The Trust understands that Section 6A of the Resource Management Act also expressly considers rivers and their margins. Taking an inclusive approach is consistent with that described by Mr. Paul. The Trust considers that assessments of natural character have a tendency to overlook cultural landscape elements, and it wishes to bring cultural concepts and values to the forefront. In conclusion, the Trust seeks inclusion of clear and practical policies in the proposed plan regarding cultural matters, setting upper limits to tell plan users what level of harm is acceptable, will assist in bringing focus to often overlooked cultural matters and encouraging decision-making that discharges Section 6E Resource Management Act duties. That's the end of my statement.
Kia ora. Thank you very much. You said earlier in your statement that you couldn't commit specialist resources to this hearing. However, that's a very well written and professional statement of planning evidence in my view. In fact, I wish more planners could write as articulate and as precise as that. So thank you very much. The effort you put into that, it must have been considerable. I look forward to reading that statement in more detail and comparing that with the Section 42A report and the provisions in the plan. I'll just see if the other panel members have any comments. Do you want to continue your question?
Kia ora, Karina. Thank you for that evidence statement. That was great. Yes, you have answered some of those questions, and I'm sure the council planner will be looking forward to read the statement as well to check your responses in regards to some of those comments. There was one that related to, and I wasn't too sure if I heard your response. It was in regards to natural character, and there was your submission talked about making sure that policy 1 of natural character was not contrary to the NPS freshwater management. And the planner's response was they were not sure what was the contrary with the policy and NPS freshwater management. Do you have any, and yeah, I was just asking, do you have any alternative wording for policy 1 for natural character?
I think initially, yes, I'm just going through the statement that I have just read out, and I think that I have alluded to the comment raised by the Section 42A author in regards to that point. I'll just find that again. While I'm finding that, if you want to ask another question, that'll be fine.
No, thank you for that. Yeah, I wasn't too sure if I didn't hear it. Well, you know, listening and reading are two different skills.
Yeah.
Yeah, you made reference in regards to amend the line with policy, national policy statement, freshwater management, concern with G. Sorry, I was just looking at it. Operational needs, you made reference to that. You've done a response, sorry. Coastal environment. Yeah, there was reference to in the general policies for the coastal environment, pretty much opposing the policies in the coastal environment layer and signalling a new policy. And you did make mention around avoid, the new policy was avoid significant adverse effects and remedy or mitigate other adverse effects on cultural values. So the planner, not just for the coastal environment, the natural character and the outstanding features, makes reference, the focus is on those values, and your couple of new policies that you've suggested make reference to all values and cultural values. I suppose what I'm trying to ask is, as you say, from a Te Ao Māori perspective, it's holistic, and Mr. Tipene said the same thing. It's not about margins separate to the whenua, separate to the moana, it's the whole thing. So I just wanted to, in the Coastal Environment Policy 10, there is that assessment component, as you've made reference.
Yes.
It talks about the cultural association. What I wanted to check was in the coastal environment for Policy 10 and those assessment criteria, and you might have answered it in your statement. The planner has said refer to Tangata Whenua Policy 6 to assess a proposal. I just wanted to check if this addressed your concern. Sorry, a little bit. You might have said it in your statement. I remember hearing something, but I...
Yeah. So I'll just go back to that. Yes, we recognise that everything is intertwined. Both my and Tepene's statement really outline that we don't see things as separate. I want to, and it's just really a thought I wanted to share this morning. When we talk about our environment, and it's always in relation to us as people, because with our environment, and you heard it today, when it's sick, it actually reflects on the people that live there. And you can see that coming through. So we don't see things as separate. And so we struggle with actually piecemealing the approaches. I want to make it clear too that we are always in triage now around the whenua. And so anything when we do a triage, it's a case of if there's a water body that's identified as significant, then that should have a different level of response because we are in triage. So things have taken place, development has already eroded our environment. And so we're not only trying to continue to mitigate that impact, but we're also having to address a proposed development that will increase or widen the impact even further. I don't know. I'm hoping I'm answering that, and I do hope that our statement articulates it more clearly than I'm trying to say.
Thank you. I saw also in the sorry, I didn't look at your submission, but the planner references in the coastal environment. There's a comment around coastal environment overlay mapping, and it makes reference to Haititai Marangai's statement wording that the coastal environment overlay should be across the Carrington Estate zone. What I wanted to just check in with you is, do you have relationships with the Carrington Estate? And yesterday we also had another, sorry, it might have been Tuesday, we had another large landowner that is on the frontage of Puheke, John Sturgeon's. I'm just wondering, do you have any relationships with some of these big landowners on the peninsula that are doing various either development, conservation, whatever it might be?
I think I'll start with the Carringtons, and we can talk a little bit around our past relationship with them when the Chinese took over ownership of that Pārakerake. We know that as Pārakerake block, and it's quite a huge area. We endeavoured to build a relationship with them and engage with them over their proposed master plan that they called it at the time. For 4 years, for 4 years, we had 10 people dedicated to being engaged around not only what they were at the time a zone to be able to do, but also what they were proposing to do that may change that current ability or right. This may come out more in a further hearing that we're coming forward where we actually address the Carrington zone, but our struggle, and I alluded to in my evidence that will be attached to the statement with Tepene's, is that the trying to, or rather not box us, I don't know if that's the right word, but when you've got an iwi authority and then you have hapu, you can recognise that Ngāti Kahu hasn't settled their treaty claims, but you can have a clash of perspective. And in our case, that was the case, where we had a entity that was stating a perspective, and then we had the hapu that was saying another perspective. And in that, we also had to make considerable effort to engage with the Far North District Council to make sure that they saw us and talk to us, and that took numerous meetings. So going back to your initial question, do we have a relationship? We do. Is it a good one? Not necessarily, no. The other one I think you referred to, the other developer, was it Sturgis? Yes, I believe that there has some engagement within our Haiti Maraengai 339 Trust that is currently in play.
Great. Okay, thank you. Thank you very much for your responses, and I appreciate your cordial today. Kia ora.
Kia ora.
Yeah, thank you very much. I've just got one more sort of follow-up question for you. So this hearing relates to the coastal environment. It relates to natural character, landscapes, and Indigenous biodiversity.
Mm.
And as you know, we love to reduce things down into their constituent parts and analyse them that way. But your evidence from a Mātauranga Māori perspective is that these are all interconnected, and that we must see them as interconnected components. Would that be fair?
Yes.
Okay. So then, I'm just sort of thinking what links them all, and is it the cultural values that you have, and the potential adverse effects on those cultural values that sort of link these components together?
Tipini?
Oh, yes, but also on another level too. We need to acknowledge that when we talk about Waimango, we're not just talking about a philosophical connection with the moana and with the rest of the peninsula. All the rivers and streams that cross over our peninsula, they are all interconnected. So if you have a negative impact in one part of the waterway, whether it's on the land or in Waimango or in the moana, it all gets impacted. So all the waters are interconnected under the surface, some on the surface, but if you make changes in one space, it can have a detrimental effect in other areas as well. So yes, there's a philosophical Māori view that all these things are connected, but actually in a real physical sense, they are connected.
Mm.
Yes, I understand that. And so I was just trying to understand how cultural values fit in with those connections as well. I sort of feel that the cultural values connect to them, with whether it's a physical effect, or I'm trying to understand what the cultural element is, adverse effects.
Yeah, I'm not quite sure what you're asking me, but I assume you're talking about, are there other cultural specific effects or impacts? Is that what you're asking?
No, I think Tipini, just in relation to your statement you raised, you talked about Manaki, our cultural values.
Are we talking about the components of a tikanga framework?
I'm thinking that's where this question is related to.
Yeah, I think that's what I'm asking. Is I'm trying to see that I can understand the physical effects and how the wellness of the environment, how it affects the wellness of the people, and that can be a physical thing. And I was just thinking, is it the cultural element that links these four components together? And it's those cultural values that you have can manifest itself in adverse cultural effects as opposed to just physical effects. Or am I not reading that right?
Yes.
I understand what connects them sort of in the way that I think.
Okay.
How do you think?
Hopefully I can answer it in this appropriately in this way. So I actually mentioned in my statement about the the markers in terms of tikanga practice around our relationships with these things. I referred to whakapapa and whanaungatanga, kaitiakitanga, and tapu and noa, utu and air. So these are all things around maintaining balance, the reciprocity of relationships between people and people in the land, people in the moana, the guardianship responsibility that we all have to maintain the mana and fulfill our responsibilities within that framework, and to acknowledge the expectations of our whakapapa in terms of fulfilling those needs on behalf of our whānau and hapu.
Yeah, no, thank you. That was the answer I was looking for, and the connection that I was looking for. I'll obviously go back and reread your statement with regards to those elements. So thank you for helping me understand that.
Thank you. Kia ora.
Kia ora. Just one more question from me. In the statement that was being said, sorry, I can't remember, might have been you, Karina, in reference to titanga, I think it's titanga.
Yes.
Is that the framework? Is that a hapu assessment tool?
It's a resource. I might be some of the planners there are familiar with it, but it's a resource that was put together by landscape and architects, and it addresses and really aligns with our approach. So that's why we wanted to make reference to that assessment tool. Is that?
And kia ora, Karina and Tipene, I appreciate your kōrero with whakapapa and your connections back to the whenua and moana, so thank you. Appreciate your kōrero today.
Great, okay, well, I don't think we have any more questions for you, but thank you very much again for a really, really well prepared statements of evidence. Again, we look forward to reading them in detail again as part of our deliberations. So thank you, kia ora. And
kia ora.
I'm sure we'll see you later here.
Kia ora. Thank you, and have a good day.
Also, so just before you go, we might we're thinking about doing a number of site visits, especially for people who are going to be doing multiple submissions. And we would like possibly to come and visit your marae and understand, you know, the coastal setting and the cultural values that you've expressed. Would you mind if we popped over to see you?
I think that if there was a request to visit, we'd be happy to support and host a visit.
Kia ora. I will look forward to that. Thank you.
Kia ora. Tēnā koutou.
Kia ora kōrua.
Okay, right, thank you. Moving right along. So our next submitter is Zaya. Who?
Zija who?
Sorry, I tried my best to pronounce your name correctly. My apologies. Please come up and have a seat at the table. Would you like to both come up? You're more than welcome.
So, yeah, I'm the husband of Zija who. So I'm speaking on behalf of Zija.
Well, as I say, you're both welcome up at the table. Come on, monsieur. You're more than welcome. Okay, now we've got your original submission, and I understand you're going to do a PowerPoint presentation as well.
Yeah, just a few slides. You should also have our so-called lay evidence opposed to 42A additional evidence.
Yeah, we've got that we've got that 4-page statement.
Yeah, so I wasn't intending to read that out. I'm assuming to take that as
well, you're more than welcome to read that to us. It's not, you're not an expert, so you're well within your rights to read it to us.
Well, we can take it as read, that was our intention.
Yes, well, we're happy to take it as read as well. So.
Okay, so my name is Ian Palmer, husband of Zija who. So the submission S242 was submitted in my wife's name. When the submission was made, the land concern was in my wife's name. As it happens, that piece of land is now in our joint names, just as it happens. The intent of being here today was primarily to avail ourselves of any questions you have in relation to our submissions. So, as I said, we taken read the submission and the additional lay evidence. But just to summarise the crux of our submission, it's in relation to particularly rule NFL R1 and also potentially R3, when it's applied to a site overlaid entirely by the coastal environment and outstanding natural landscape overlays, which, as we read the rules, results in constructing certainly any dwelling, I think anything bigger than 25 square meters, and the associated earthworks with that, it becomes non-complying. And then when you read the associated objectives and policy, and as we understand it, but if it's non-complying, you have to then show that you're not you're in compliance with the objectives and policy. That in this case, it'd be very difficult to be entirely compliant with those objectives and policy, because essentially they're all about maintaining the naturalness of the land, and obviously building a house on the land obviously doesn't maintain the naturalness in its entirety. And the Section 42A report makes clear the expectation that the resource incentive in those circumstances wouldn't be consented to. And we argue that that's potentially in conflict with the Resource Management Act. As you no doubt aware, in a number of places the RMA uses the language makes land incapable of reasonable use, and essentially says that's a no-no, and we argue that this rule applied in this circumstance is in conflict with that intent of the RMA, particularly referring to the particular sections 85, 3A, 3B. I'd also like to say that while our submission addresses a particular piece of land that we happen to own, our submission, a concern is of a general nature, not just specific to our particular piece of land. Although I would say, in relation to our piece of land, and we said in the submission that we're asking for either the rule to be changed or the O&L overlay areas to be changed. I guess if the decision was not to change the rule, then our position is more strongly, of course, that the O&L, particularly in relation to our land, should be changed. In particular, in relation to our land, I guess we object to the O&L entirely covering a cow paddock of ours, which happens to be the only prime building site on that particular land. We don't object to the O&L covering the rest of that site, which is regenerating native bush. And in fact, I haven't put this in the submission, but subsequent to the submission, we've actually put conservation covenants on all that regenerating native bush. So obviously we don't object to the overlays and the rules associated with that. The only other point I wanted to raise on the next slide is I can't claim to have read all the post Section 42A submissions, but I did read Peter Hall's submission, and he raised a somewhat similar point where he makes a comment that in the circumstances we're talking about here, combination of CE and O&L covering an entire site, he said the comment said there should be a reasonable expectation to be able to build on such a site, and he also notes that particular provision has been made in these circumstances in the Ōmāpere district plan. I guess we just raised a couple of questions for you in relation to his comments that is it a reasonable expectation, or is it a legal right under the RMA, should you have be able to build a house on your site as of right, and if it's even if it's a restricted discretionary situation, that doesn't give you as of right the ability to build a dwelling, because there's still the discretion, and the restricted in this case presumably would be restricted to the keeping the area in its natural state, which when you're building a house, you're not keeping it in its natural state. So QED, there's potential, even if it was restricted discretionary, to be denied. We argue, therefore, that to be compliant with the RMA in such circumstances, there should be no more than control. So to preserve your ability to build a dwelling on the site as of right. So that's the essence of our submission. Obviously, there's more detail on our submission and the subsequent post-section 42 lay evidence, which will take it through.
No, thank you very much, and thank you for linking it with some other evidence as well. That's helpful for us.
It's quite astute of you to be looking at the evidence of Mr. Peter Hall in that respect, because he goes into a considerable detail on these sorts of matters. Is there an existing dwelling on your site at all?
But not on this particular site. We have a dwelling on a different site.
Yes, yeah. I mean, that's where the idea of the reasonable expectation comes in, whether that's necessarily a legal term or not. But in most cases, the way the plan is written at the moment, I put it to you that there would be a reasonable expectation of you being able to put a dwelling on it. You'd have to go through that non-complying activity consent application, which is not an easy task to follow. Yeah. But non-complying is a rather harsh term. Sometimes a non-complying activity is just something that's an exception to the plan or something that hasn't been anticipated. It's not a complete veto of anything on the land at all. But having said that, on the other hand, it does mean going through an application and expending some money in doing so, and engaging potentially an expert, perhaps a landscape architect, to help you with that.
Yeah.
But I think what Peter Hall's been talking about is not necessarily controlled activity, more in terms of a restricted discretionary activity where council identifies the particular attributes that they're trying to maintain or look after, and then you address those specifically in terms of your application. So,
but our point there is the restriction would be to preserve the naturalness of that location, and Section 42A report makes it fairly clear that and it's an absolute protection. I can't remember exactly the language that and that it wouldn't be possible to argue that you're absolutely preserving the naturalness of that site by building a house on it. And I think in the rules in the RMA for decision making for non-complying essentially means that you have to show that you're absolutely in compliance with the policy and objectives. In this case, I think that would be difficult, hence the problem with restricted discretionary as opposed to controlled. But I mean, that's sort of part of, if you like, half a submission that in general, any site that's entirely covered by CE and ONL, I think we're the only places we practically build a house covered by CE and ONL, there should be exemption, something along the lines of the Wrong Ray one, although we should be controlled on restricted discretionary. But then separate to that, I guess, if you like, we think it's a bit onerous to have to describe our cow paddock, which is a pretty ordinary cow paddock, as outstanding natural landscape. When essentially the essence of it is what we're saying is that people on the other side of the harbour would prefer to look out across the harbour and not see any houses on the landscape. Well, we look out from outside the harbour across there and see hundreds of houses, and we can't object to that. And there are already other buildings on this, not on our property, on this strip of this ONL 17, Mongaree Harbour ONL, where perhaps not have gone through the resource consenting process. They should have, but anyway, they're there. So that, this wouldn't be the first dwelling on that piece of land. But, there's a pretty ordinary cow paddock, outstanding natural landscape anyway.
So how close to the Pātanoa Peninsula are you there? Is it the Pātanoa Peninsula?
No, we took the Rangitoto Peninsula.
Down the other side.
Opposite
Yeah, so this is the eastern side of Maunganui Harbour. So, the key thing which is driving the ONL put on it is when you're over at Mill Bay, for example, you're looking across the harbour onto the Rangitoto Peninsula and Butler Point, and that's part of our land.
You're almost opposite fish and chip shop, aren't you?
Yeah, you can see our property from the fish and chip shop. You can see our cafe from the fish and chip shop. That's right.
Can we get the officers to make a comment on that at all? Is anything you wish to add on that?
So, I guess for the avoid direction that you're referring to, which comes from fire order documents, it doesn't mean an absolute no. Like there is the ability to sort of demonstrate that you've got minor sort of effects and meet that threshold. It is, admittedly quite high, but that comes from fire order documents.
But it didn't exclude, the language did not exclude minor effects, it just said avoid effects, period.
Yes. So the way that has been interpreted, and this gets a little bit technical, is that you can have minor effects and meet that threshold.
But if you've got a house on a piece of land, it could easily be argued, the planner is looking at that at the time, that building a house on a otherwise, cow paddock, that's not a minor change to the outlook on that. That is actually arguably quite a significant change to the naturalness of that environment. If therefore the planner would be compelled, because it's not complying particularly, to deny it. And certainly the way the Section 42A report is written, the language used in there makes it pretty clear that the expectation that it would not be consented to.
Yeah, the problem probably is that it's really a discretionary approach to it, and it really relies on an applicant such as yourselves coming forward with a proposal that does address some of the concerns that the planner might be looking for. So you might find that it's a house of single story that is set back into the bush, so there's landscaping, there's particular design features, and that's the way we're like, I know there's a landscape architect online at the moment watching us. Those sort of people specialise in helping in that sort of thing. But the concern you're expressing is that you have to go through that discretionary decision-making process.
The concern is not having to apply to resource consent.
Yeah.
The concern is the risk of it being denied.
Yes, yeah, exactly.
Yeah, look, I think I understand where you're coming from. With a controlled activity, it can't be refused consent. So you're saying, I'm quite happy for you to have control over how I build the dwelling.
Correct.
But I don't think you have the right to turn it down.
Yes.
At the risk of jumping down a planning rabbit hole, the intention of a controlled activity when it was first invented as a thing was that's what it would do. However, the way that case law has interpreted what a controlled activity can do has really pigeonholed it into a really narrow area of how much control a council can have. And I think a number of councils have come to the conclusion we're quite happy to grant controlled activities as long as we have enough control. And it can be argued that if you've applied for a consent to put a dwelling in a certain location as a controlled activity, the council does not have the control to move that dwelling. They have control over what you clad it with, they have control over what colour it is and the materials, but the council have become frustrated with the straitjacket that a controlled activity has. So it's then moved to restricted discretionary, which gives them more control over the things that they can influence, but it comes with the added risk that they have the power to decline it. Now that doesn't mean that council will exercise that power. And in fact, I think the approach to the way restricted discretionary activities are working these days is that the council's really clearly set out what narrow matters that they're going to focus on. And whilst there is the possibility that it can be declined, and one would think in extreme circumstances perhaps they should be, I think you need to I think the proposition is that council will not be seeking to decline these applications. They'll be seeking to just exercise a reasonable level of control to maintain those matters of national importance that relate to the coastal environment and outstanding natural landscapes and outstanding natural features. I don't know whether that gives you any comfort, but I understand the concern that you have, but that's particularly it's a function of the regulatory regime and the legal framework that we have to operate within.
I hear what you're saying, but the problem here I see is that if it was restricted discretionary, the obvious thing it would be restricted to is preserving the naturalness of this piece of landscape. And
so you're
how can you argue putting a house on an area that's currently grassy paddock that doesn't preserve the naturalness of that environment, it changes it. Therefore, the planner could say, well, you're not honouring the policy and objective, so I'll use my discretion to say no.
Yeah, so I think what this comes out again, this is going to become a little bit subtle, is avoid adverse effects, whether that means avoid all adverse effects. Now, can you give us your interpretation as to how that is to be interpreted?
Yes, so it's directed for sure, but it's not an absolute. Like it's not you can't do anything on your land. You need to demonstrate that you've designed it in a way that's better for the landscape. And
in theory, you could build a dwelling that has some adverse effects that would still be granted consent.
That's not the way the policy worded. The way it's worded is the way I read it.
So I'm asking the planner,
Sure.
how is that word to be interpreted?
yeah,
And how is that word to be used in the planning context?
But how does he know who the planner on the day is going to interpret what he may have thought he should have interpreted?
Well, it seems to me, I mean, again, we're going down this rabbit hole, but that's the way that case law has taken us.
yeah.
So when you say, the proposition point to us, proposition point to us is, it is not an absolute avoid all adverse effects. It's avoiding significant adverse effects.
Yeah.
So that means that there is a threshold of adverse effects which are minor, or even less than minor, which are tolerable within an outstanding natural landscape. Now,
Well, then the word significant should have been put in the policy, but it's not.
so again, I'll ask our reporting planner to explain that.
Now, this is all directly related to national policy, so that the PDP needs to work within those constraints. And there is two different thresholds. There's an avoid adverse threshold, there's an avoid significant adverse effect threshold, depending on where you are located and the significance of those overlays. And the thing around avoid, which is really sort of quite a planning technical manner, is there's a large body of case law around how that's to be interpreted, and as the chair said, that does allow for minor kind of transient effects, so it's not an absolute. I recognise that means it's a difficult consenting process you may have to go through, but I think we're bound within those constraints in terms of the higher order documents and the fact that this area has been identified as having outstanding values.
That'll be up there then. Yeah, okay. And just going back to, as well as whether there should be a rule, as there is indeed in the Ōmāpere Council case, or we might argue if there was such a rule, it should be restricted discretionary rather than control. But that's one angle that we're arguing. But or particularly if you were to have a rule like that, and even if the rule was restricted discretionary, not control, we'd still like you to consider reducing the coverage of this particular ONL, and also to consider ONLs in general, where they cover the combination CE and ONL covers all the area of a particular site where it doesn't currently have a dwelling where you could build a dwelling. That you should say, well, okay, we'll at least give you this little bit that you could build a dwelling without it being covered by CE and ONL, or have this particular rule that that makes provision, as they have in Ōmāpere, for this circumstance.
And we can look at that point as well, the extent of the ONL.
Yeah, that's a fair point. So I noticed that we've got the council landscape architect who did this analysis online, Ms. Absalom. Ms. Absalom, are you there? Okay.
I guess it's the other.
Kia ora, Ms. Absalom. You've been hearing some of this exchange, I take it?
Kia ora. Yes, I am hearing.
Yeah, so the discussion's moved on to like the extent and whether outstanding natural landscape should apply to a parcel of land. I'm just wondering if you can help us with the submitters' questions on that regard.
Certainly, I'll attempt to elaborate on that. It's quite clear from the worksheets that were prepared at the time of the ONL identification that dwellings are fairly frequently occurring inside ONLs. In my opinion, the fact that the ONL lies over this property does not mean that a house cannot be built. What it means is that a house that has been carefully designed for that particular environment, which needs to go through a consenting process, can be accommodated without the values of the ONL that have been identified in the worksheet being sufficiently undermined that consent should not be granted.
But what she's saying is inconsistent with defining that situation as non-compliant.
Yeah, no, thank you for that comment. Thank you, Mr. Absalom. Just perhaps you just want to hang around and we may come back to you with some further questions. So anyway, so that's a
If I may just add, you will be hearing later this morning from Mr. Burns, who is talking about a whole series of properties where houses have been constructed in ONL. The overlay does not prohibit the construction of dwellings. It requires a careful design and assessment process to be undertaken before they can be built.
Yeah, a main part of the submitter's concern is it being classified as non-compliant, and it's what that envisages rather than what it actually means.
The dwellings may have been built already on land that's proposed to be ONL, but the new rules don't apply to existing dwellings. We're talking about a piece of land that has no dwelling, a site that has no dwelling, and you're subjecting to these new rules. So the fact that there's existing dwellings there on ONL is not the point.
Well, with respect, sir, they have been constructed during a period of time when the ONLs were on them.
Yeah, but not this proposed plan rules.
In terms of the activity, sorry.
Well, questions are meant to come from myself as chair. Well, yeah. I don't want to backwards and forwards with this. Is under an expert. So, thank you, Ms. Absalom. You've explained the position really well. I completely understand where you're coming from. We do actually have some other questions from other panelists, so I don't want to wrap things up just yet. I want to give everybody a chance to I think Mr. Kenzie Lewis also happens to be a landscape architect. So,
thank you for your evidence and submission. I just wanted to clarify. I think I've got pretty clear about which is your property. I'm looking at it on the screen. Does your property have a nominated building platform as part of the underlying subdivision that happened? So it's a clear title. And do you own the land to adjacent?
Yes, we do. There is a complexity, if you like. Subsequent to this submission, we've done some boundary change. We had 3 titles, and we've done some boundary changes such that the land we're talking about here is now combined with some additional land, which arguably is not an ONLC combination. So you could build there, albeit depending how we end up being zoned, we potentially, would stuff like this piece off so that we're back to the same situation we're talking about here. So that complexity, we have a dwelling on a separate piece of one of our other old 3 sites.
Okay, and that's answered the question. Thank you.
Yeah. Okay. No, look, we completely understand. But now, what I want to say is that the activity status is definitely in flux. The final activity status on these types of land are certainly open. We haven't made a determination yet. We've got a council officer's report that has given us some advice and a recommendation. We're going to be listening to all submitters. As you say, there'll be another submitter making quite a similar argument for a number of property owners. So we've still got an open mind, and we certainly understand, I think, where you're coming from. Thanks again thanks again, Ms. Absalom, for your contribution. We haven't got any further questions, but thank you very much for your evidence and your attendance.
Thank you.
Thank you. Thank you. Our next submitter the next two submitters have turned up, and I've loaned them and they're not answering their phones.
Okay, well then, I suppose you can just perhaps take the adjournment now. We won't try and pass Mr. Bird up, so we'll adjourn now in 10 to 11. Okay, so we've got a couple of no-show submitters, so we'll just take that opportunity to adjourn now, and we'll come back at our scheduled time at 10 to 11.
Stopping recording.